Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Phil Powell analyzes a purchase and sale agreement for a vessel. So let's tear it down. Phil Powell, welcome to the Contract Teardown Show. How are you today?
I'm fantastic. Thanks, Mike.
Phil, we're going to get into the nerdiness that calls back to my pre-law career. I don't know if I told you this, but I used to work in logistics. I worked for an intermodal company. We talked about flipping boxes all the time, which was these big containers off of these chassis and these boats and just craziness. And so you work in this space, so we're going to talk about that. We are specifically talking about this document I'll share with the folks at home, the Vessel Purchase and Sale Agreement. Phil, what the heck is this?
This is a document that transfers the ownership of vessels and kind of assigns the rights or liabilities of that ownership to the purchaser.
Got it.
Specific for maritime law.
Awesome. And so when we're talking about vessels, this is as large as the Ever Given getting stuck in the Suez Canal or whatever it was. Boats that large down to
even pleasure craft. They would all approach.
Yeah, all right, a dinghy qualifies. All right, very good. And before we dig into it, Phil, tell us about you. What's your background? What brings you to documents like this?
I have a background in maritime law. I'm the general counsel for a company that owns and operates fishing and research vessels. And so, again, I have an LLM in maritime law. So I specialize in this sort of thing and write these quite often. In this sort of
stuff. And I think it's an interesting context because it is a context. It is an unusual context, but it is also exemplary, right, of a contract type. It's like just removed enough from people's everyday that they can think carefully about it. So, all right, we're going to go down to section 2.3, conveyance. This vessel is to be conveyed according to the following terms. Whole bunch of capital letters. That's how you know it's super important, Phil. What do you think about section 2.3 and what we're trying to do with the conveyance section?
So this particular document's written for a very simple vessel sale and purchase. This is how you describe what the vessel is capable of doing, whether there are any warranties associated with it. Here, I've waived all the warranties for kind of implied fitnesses for particular purposes or anything like that. It's an as-is, where-is sale. And you'd want to be very particular about how you write this. And this is where you would be negotiating or drafting kind of classification societies or something like that. It's the condition of the vessel and what they're getting.
Yeah, speaking of around conveyance, there's a bunch about the condition. There's a description of the vessel in 2.2. 2.4 talks about risk of loss and delivery. 2.5 talks about if the vessel is damaged or destroyed. I assume most of this is trying to just establish, sort of a meeting of the minds. This is what we're trying to do with this document. If X happens in the meantime that undermines our intentions, then after that action, we got to rethink the original agreement. Is that basically what you're trying to do with the rest of 2?
Sure. Given that it's a vessel, it has a particularly salty flavor to this document because it has to account for certain risks that just don't exist in shoreside, and you have to think that you're selling something that's floating. So should something occur, you want to figure out, when a risk of loss occurs, when that insurance should happen, and what happens if that happens in the interim prior to closing. Yeah.
So what else do you need? I'm looking at 2.6. It talks about further assurances. You need other bills of sale, endorsements, assignments. When you're doing this sort of closing, so there's been an offer, an acceptance, and a boat. A dinghy is changing hands, and somebody needs to make a decision about about whether they're purchasing this boat or not. What other documents will surround this kind of purchase?
So typically, this would be go with the obligations and closing and conditions precedent to closing is you have to transfer these vessels. Typically, for my particular class of vessels, they're commercial, and they'll have a federal registry or coast-wise endorsement, and then even like a fishery endorsement or sub-endorsement. A lot of these have to be Jones Act compliant, meaning they have to have American ownership, and there's documentation requirements to transfer the ownership of those vessels. And so that would be a condition precedent to closing. But in terms of the conveyance section, that's actually just describing the physical asset and what it is.
Yeah, I'm looking over this whole document, and I mean, again, you tell me, but generally it looks like a pretty common, buy, sell, people are buying something, and it feels like you're using other documents outside this document to contextualize, to make sure that it functions in the particular context. Am I reading that right?
Sure, and that's why, like, this one doesn't have many documents, but in the documents section that as part of the conditions precedent to the obligations of the parties, the document section would list out all the documents that would be associated with this to provide this document context. The other thing I think to understand is, and why the other clauses are written the way they are, because this is a maritime contract, courts are very deferential to sophisticated parties transacting. And these clauses will get very strict adherence in court. So it's written in a way that contemplates that reality and that commercial reality. But yes, you're right. There are going to be a series of documents that also accompany this document, and the provision of those documents is part of the conditions to closing. That's just almost as important as delivery of the vessel and where you're going to deliver it.
Yeah, let me see if I can, for my sake, let me step you back in that kind of. When we're dealing, you mentioned that courts are very deferential because of this jurisdictional issue. Dig into that a little bit. Tell me about how, if I'm drafting contracts for this kind of sale, does that mean that I put more on this particular document because I know a court is going to trust it? Should this look like something a court is really familiar with, and then I use these other documents for, specialty issues? How are you drafting in a way that's mindful of that court's reading, that relationship with the maritime law?
So that's going to be fluid, depending on what party you're coming from. But like the more important things I would think about would be like indemnity agreements and things like that. Whereas, in shoreside law, there are state laws around what the extent of indemnities you can agree to and that will be enforced upon you. Maritime laws, again, more deferential. And so when you're talking about risk allocations, you're going to be more specific and more extensive. In terms of the vessel, if I was the purchaser, I would want to be very specific about what's being conveyed, what can I expect, where is it going to be delivered, and in what condition, and what happens in the interim. So I think just depending on your party and your perspective, and that's just contracting. In some cases, you want to be more ambiguous depending on your party, and in some cases, you want to be more specific. It just depends on your interests. And
Yeah. Speaking of, I'm looking at the indemnification section, which is section 8, and I'm interested. There's the typical stuff that you see in indemnification. Everybody's held harmless and all this stuff. But I like the indemnification procedures section that you talk about in 8.3. I mean, there's a lot of specificity. Talk about how you're writing this section and how it relates to this particular context of a purchase of a vessel.
So you get into where it could be you're arguing about the indemnity that could be owed, about a substantive liability or something that may have happened. I think that in terms of indemnifications, this is actually a purchase and sale series of indemnities. More traditionally in commercial maritime law, you'll see knock for knocks and more activity-based ones. But these were, more contemplating ownership of the vessel and prior to closing and the different agreements here. The indemnification procedures, I think, just takes out any kind of ambiguity as to what happens in the event that this indemnity has to go through, so you don't find yourself, concerned with procedural stuff and ignoring, substantive realities while you're trying to sort through procedural stuff.
Right, and to underline that point, to make sure that I understand it, if I'm in a state court and I'm doing a purchase, I know that behind that state court behind that contract there's a state law that's going to fill in all the gaps. Like if there's anything unclear in the contract, it's going to fill in all the gaps. But it sounds like when you're dealing with maritime law that you want as much as possible to fit into the contract, to not mess with the
potentially. Yeah. So you can still bring some maritime claims in state court. They're either removed to federal courts or not. It's kind of an admiralty jurisdiction thing. And in some cases, parties can argue that, adjacent state law should fill in the gaps where maritime law is. This is just something that's kind of unique where maritime law is concerned. For example, maritime insurance, marine insurance cases are adjudicated. Marine insurance contracts even are adjudicated by the adjacent state law rather than some sort of federally entrenched precedent. But whether you're leaving room for a state law to move in or leaving room for other general maritime law rules to happen, you can sort of circumvent that outcome with just being very specific in terms of what you want in the contract itself.
Jumping down to 9, it is called miscellaneous. This is the section you see in a contract that often just has a bunch of boilerplate that nobody really reads, right? Like the lawyers are, when you pass around this contract that, your notice, for example, your notices are going to be, there's pretty common standard practice that's usually pretty context specific. Businesses of this kind usually communicate in this way, kind of thing. How are you using this miscellany, this section? How substantive are you seeing these subsections under miscellaneous? How much attention should we as drafters pay to this miscellaneous section?
In the context of a vessel purchase and sale agreement, quite a bit. Again, given the way that courts handle maritime contracts, your decision on jurisdiction, venue, governing law, and notice is going to be that's going to be the rule of law. That's going to be what counts. And so you'll want to think, where do you want to litigate? What's more convenient if it comes to pass? What sort of dispute kind of resolution proceedings do you want to even envision? This one doesn't really contemplate arbitration, but that's a big issue in maritime law where arbitration clauses are, fairly universally deferred, adopted by courts in enforcing contracts. And so these boilerplate provisions, where they are seemingly boilerplate, I think in the context of a maritime contract, they have special importance, and you should definitely take a moment to think about the realities, because again, vessel purchases and sales are necessarily interjurisdictional and give rise to a lot of variability there.
Yeah, and I mean, obviously, we at Law Insider take the position that nothing is really boilerplate; that everything should be conscious decisions. We know that contract lawyers, use copy paste all the time, but we want people to make sound decisions. We even did an ebook recently on the notice provisions because it can be such an issue. Well, as I step back from this and I think about the sort of the unique context, I want to ask you a very general question, which is, if I'm a drafting attorney, you know how it is when you're in-house, you're dealing with all kinds of stuff. I mean, the spectrum of issues. And one of the big decisions is, when is this beyond me? When am I at the point where this purchase that looks like a purchase of, I bought boxes of paper from, an office supply company. When is the line at which, if I'm making a purchase agreement like this, that I say, okay, this is beyond me. This is the point that this is more than I can handle. I need to go defer to someone like you who has more experience in this area.
I think when you get to where you're not quite understanding the corollary things that must go with vessel ownership to make it commercially viable. I know for a fact, like we're discussing, as a condition precedent to closing, sort of the documents that must be accompanying with the vessel. As a maritime attorney, I understand endorsements, and I understand the different kind of required documentation that's required. I think if you don't have a handle on that, and then you don't really know what you're buying, because in addition to just the floating asset, you're buying the rights that are associated with that floating asset if it is in fact documented and endorsed. You're also, acquiring the obligations of citizenship or any number of things that can affect the value and viability of that vessel.
Yeah, it's again, what we want is for people to be able to make conscious decisions. And if you're facing a document like this and you see you're moving language over and you're saying, there's a level of discomfort that people are okay with, where it's like, I don't totally know what this means, but I trust the contract that I found. I trust this copy paste activity. And then there's a level of discomfort where you're like, holy cow, I don't know what's going on right now. So
I would say I'd be comfortable with a boilerplate type approach like this, as long as you're, aware of the jurisdictions. Until you get into classifications, and when we start really getting into nitpicking that conveyance section, because you're determining what type of vessel, what's it good for, what are its classifications, what are its endorsements. If it's not an as is, where is, the devil can be in the details, and you probably need some technical knowledge to best be able to understand and then describe in your document what you're actually conveying physically, and then in terms of rights and obligations.
Well, we know at this point, if I have any boat questions, I'm coming to you for sure. For people at home who want to do the same, who are running into a document like this and just sort of lost in the weeds, what's the best way to reach out to you, Phil?
I'm actually in-house. So I work for one particular company, but I would say.
So they can't hire you, but they might be able to learn from you. You might be able to point them in the right direction.
I can certainly do that. So if they were to go to www.globalseas.com and look under team, they'll find me and my contact information, and I can be emailed, and I'd be happy to answer a quick question or point them in the direction.
Awesome. That's exactly what we need. And for those of you who want to show up on the Contract Teardown Show and beat up a document like this, just email us. We are at community@lawinsider.com. Phil, thank you again. We will see you guys next time.
Thanks, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.